going to have blood vial chart again. We lowered and then put it back up again. We'll go back to it. Thank you. Mr. Matheson, directing your attention to the vial that's been marked, the photograph of the vial that's been marked 228 vial.
I think the photo was 229.
You're right, Your Honor. I'm sorry. 229. It's actually sort of hard to tell for some reason on the Elmo, but in this picture, is this vial actually standing up? Do you need to see the picture?
No, I can. It appears it's standing on, well, it is. It's standing on the bottom part of it with the cap on the top.
Now, Mr. Matheson, was there an occasion where the blood vial was measured by someone else in your presence using a ruler?
Yes, there was.
And a notepad?
Yes.
Who did that?
Mark Taylor?
Is he a person who works for SID?
No, he is not.
Who does he work for?
He is a criminalist, works for himself. He's a private.
Was it your understanding he was retained by the defense in this case?
Yes.
Now, when he was measuring this, can you tell us what kind of a ruler he used?
Would object is irrelevant.
Oh, well.
It's just a plastic ruler, approximately 15 inches long.
Why is the blood vial standing on a pad of paper?
Well, that particular ruler, like a lot of rulers, the measurement does not start at the end. It's actually inset, I don't know, 3/16 of an inch or a quarter. So if you ding up the end or knock around the end, it doesn't affect your mark or the beginning point. So an attempt was made by using the notepads to bring it up and account for that little bit of the ruler. So the bottom of the tube was at the same height as the bottom of the ruler, or the beginning mark.
Mr. Matheson, doesn't that seem like an extremely inaccurate way of trying to measure the blood vial tube?
Argumentative.
Sustained.
What is is this the preferable way from a forensic standpoint of measuring a blood vial?
No, it's not the way.
Objection, move to strike this testimony.
Oh, well.
It was not my choice the way to do it. I preferred the equivalent amounts of water.
Now, Mr. Matheson, when you actually did your own measurement of the blood vial using the technique of equivalent amounts of water, did you actually have to stand the blood vial up similar to as is depicted in this photograph?
Yes, I did.
And when you measured that, did you take into account the amount of blood that is clinging to the inside of the vial?
No, I was measuring the amount that had collected in the bottom.
And if you look at the top of this vial, there appears to be something a little less than, hold on, a quarter of a, it looks like it's a little less than a quarter of an inch or approximately a quarter of an inch of blood that's stuck up towards the top of the vial.
Objection,
Sustained.
Well, sir, how much, let me take a look at the photograph. Maybe I can show the photograph. It's hard to tell. May I approach for a second?
You may. I think that's the centimeter
You're right.
scale on the
You're
side.
right. Can you tell us how much the measure is, or the approximate measure is, of the blood that's up towards the top of the vial?
Objection, no foundation.
Sustained.
Is there a ruler right next to it?
Yes, there is.
And using the ruler, can you tell us approximately how much blood you can see in the darkened area at the top of the vial?
foundation?
Sustained.
Well, when you saw the vial, was there blood that was stuck up at the top of the vial?
Normally there is. I don't remember if there was on this particular instant.
Okay. And how does it,
Non-responsive.
Overruled.
why is there blood stuck up at the top of the vial? How does it get there?
Well, many times, or usually when the blood vial is being stored, it's in a envelope. A lot of times it's upright. Sometimes it can be upside down or falling on its side. The blood comes in contact with all parts of the inside of the tube, and some of it's going to adhere up around the stopper.
And did you do your measurement of the 2.6 milliliters after the Mark Taylor measurement, to your recall?
I don't remember. I believe it was before.
All right. Now, with respect to do you know whether there was any more removal of blood between the Mark Taylor measurement and your measurement?
Not to my knowledge, no.
And when you measured the vial, did you take into account any blood that was up around the top of the vial?
All I did was measure the part that had settled down in the bottom of the vial.
And Mr. Matheson, are you willing to come to any estimate as to how much blood in this particular picture is at the top of the vial and the inside?
No, I am not.
And is that because you've never made any scientific inquiry to try to find that out?
Sustained.
Why aren't you willing to estimate?
Because I'm not even sure how we'd go about measuring that. It adheres to the vial or the cap. When you pull it off the cap, it may adhere to the cap, may go down the side. I don't think you could do a good measurement of that.
And as a forensic scientist testifying in court under oath, would you be prepared to give what would just constitute a guesstimation of that amount?
Not of that amount, no.
Now, I'd next like to show you the microcentrifuge tube that the photograph of which I've marked as 230 for identification. Sir, before I ask you about this, other than the incident in court the other day, where you were handed a vial of water that purported to contain 8 milliliters and poured it out and saw that it actually measured 7.5. Was it 7.5?
That's what I measured when I poured it, yes.
Other than that, have you ever tried to make any inquiry as to how much blood will stick to the inside of a vial?
No, I have not.
Now, with respect to the microcentrifuge tube, when you looked at the microcentrifuge tube, did you attempt to measure the amounts of blood that are stuck to the interior portion of the vial over where the blood line itself is, and also the portion up near the cap?
No, I did not. I just measured the amount that settled towards the bottom.
And again, as a forensic scientist, would you be willing to give us any estimation as to that amount?
The amount that wasn't measured?
Right.
No, I would not.
Is that for the same reasons that you testified to previously with respect to the blood vial itself?
Yes.
So there's some unknown amount in both vials that you did not measure, is that correct?
That's correct.
And in order to represent the unknown amount, can you just place the little white item that's in front of you onto the defense blood vial chart? Maybe we can put the blood vial chart back up. Your Honor, perhaps we could pass around a picture of the vial and the microcentrifuge tube, because they are a little bit difficult to see on the Elmo.
229 and 230?
Yes.
All right, hand them to juror number 1, please. Goldberg, would you collect 229 and 230 from Deputy Russell?
Now, Mr. Matheson, on the chart as it exists right now, we have 1, 2, 3, 4, 5, 6, 7 numbers, and all of those are estimations. Is that correct?
Yes.
So would it be fair to suggest that the total number of estimations that we have, we know to be completely accurate?
Objection leading.
Sustained.
What can you say with respect to the accuracy of the total number of these estimations?
I'm not sure what you mean by the accuracy of estimations.
I think you're talking about the precision of measurement.
Well, that they are all estimations. It's give or take a little bit of blood. We don't know exactly how much was used in each of those instances.
And do you agree, Mr. Matheson, that to try to reconstruct and account for every tenth of a milliliter of blood, or even quarter or half of a milliliter, would be a hard thing to do?
Sustained.
How hard would it be to try to go back and to account for every half a milliliter of blood?
I think it'd be a very difficult thing to do, to try, and even if you were from the beginning trying to account for every little bit, there are aspects of this that are very difficult to measure, and it would be hard to account for every portion of blood that's used in this type of testing.
And in any past case that you are aware of, has SID ever attempted to do that, to account for every half milliliter of blood in a test tube?
No, we have not.
And why not?
I think we've asked this
Okay.
question before. Why
Now-
don't we move on?
Okay, thank you. Now, Mr. Matheson, understanding that these numbers that you've provided are estimations, can you calculate the total estimated amount of blood on this chart under these conditions?
Objection, asked and answered.
Overruled.
If you have a calculator, you could use that too. That'd be faster.
Well, the final figure that I come up,
No foundation.
well, the final figure that I have by adding up the numbers that we have up there is approximately 7.5 milliliters.
Okay. And Mr. Matheson, there is then, in addition to that amount of blood that's occupied by what we have in this diagram as the white space, which you have not provided us any number for, is that correct?
That's correct.
So under our estimation, we have approximately 7.5 plus this unknown amount.
Yes.
Now, Mr. Matheson, I want you to assume, hypothetically, that at the time that the blood vial was drawn, that there was an estimation between 6.5 and 7 milliliters of blood being in the vial. Or to keep the math simple, let's assume it was 7 milliliters of blood.
Objection. Assumes facts, not in evidence. Improper hypothetical.
Sustained.
It was the same hypothetical they gave, Your Honor.
No. Different hypothetical.
Sir, if you were to assume, for the sake of this hypothetical, that at the time the blood were drawn, there was 7 milliliters of blood,
All
and
right,
that we started...
let me see counsel at the sidebar with the report, please. Mr. Goldberg.
Sir, your own margin of error, you said, in visually approximating what is in a blood vial, just visually, was upwards of 1.8 milliliters? 1.8 milliliters or more, did you say?
Well, in the particular instance that we mentioned, when I estimated to begin with, I was 1.8 off, yes.
Now, let's assume hypothetically that the blood vial in this case had 7 milliliters at the time that it started out at the scientific investigations, at the time that it was drawn. Would that mean that under our hypothetical of the set of numbers that we came up with, that there would be an approximately 0.55 milliliters of blood? Too much.
Approximately a half a milliliter, 0.5, yes.
Well, Mr. Matheson, when you go back to the laboratory, are you going to launch an investigation to determine whether someone added more of the
Sustained.
defendant's blood to the vial?
Sustained.
Now, Mr. Matheson, you were asked about EDTA yesterday. You remember that?
Yes,
And is the blood vial in this case that was used to contain Mr. Simpson's blood, in fact, an EDTA vial?
yes, it is.
And it's your understanding that that is an anticoagulant, is that correct?
Yes,
Now, is it also your understanding, Mr. Matheson, that this anticoagulant is one that can be tested for?
as I mentioned, the fact that it is a chemical, there are instruments available, I would assume they can test for it.
And did you cause the blood vial to be sent to the FBI along with items 13, the socks, and the items from the rear gate for the purposes of EDTA testing.
I don't believe I was directly involved with it, but it was sent.
Now,
Right, no foundation.
Do you have any personal knowledge of that being done?
As far as having physical, I've seen records to that effect. I have not.
All right, jury is to disregard the last question and answer.
and is it your understanding, Mr. Matheson, is it your understanding that if blood were taken from a EDTA vial and planted somewhere, you should be able to find it?
Objection, no foundation.
Sustained.
Now, Mr. Matheson, when you testified as to the people's evidence disposition summary, did that reflect a transaction where certain items were sent to the FBI for purposes of EDTA testing?
Objection, no foundation. Ask and answer.
Sustained.
Now, Mr. Matheson, have you heard that according to the report of the EDTA testing,
Sustained.
Mr. Matheson, hypothetically, if the FBI testing showed that there was no
Objection.
EDTA,
Sustained. Sustained. Counsel, ladies and gentlemen, you were to completely disregard that last series of questions and answers regarding EDTA.
can we approach on that, Your Honor?
No, you may not. Proceed.
Sir, are you aware of any evidence of EDTA in item 13, 15, 16, or 17?
Objection.
Overruled. Did you do any testing on that yourself? Yes or no?
No, I did not.
Next question.
May I have one moment, Your Honor? Now, sir, do you recall answering a question on cross-examination, a hypothetical question involving if there were EDTA on the socks and the rear gate, what effect that would have?
Yes, I believe so.
Do you know what the basis for that hypothetical was?
Objection. No foundation.
Any others? Sustained.
Okay. Are you aware of any facts that constituted the basis of that hypothetical?
Objection. No foundation.
Sustained. It's not a proper question regarding hypotheticals.
Sir, if the facts of their hypothetical were changed so as to indicate that the testing revealed the absence of EDTA.
Sustained. Counsel? Ladies and gentlemen, jury, we're going to take a recess, brief recess right now. Please remember all of my admonitions to you. I'm sure you take them to heart. Take a recess for 15 minutes as far as the jury is concerned. Mr. Matheson, you can step down. At EDTA testing.
Well, I agree with that, Your Honor, and I agree that it would have been appropriate to have sustained the objections to the questions that I asked. But I also believe that the objections to the questions that they asked exactly along this line, and the hypothetical they gave exactly along this line, where they stated that there was no EDTA, and if there was no EDTA, would that indicate that it came from the blood vial? And the witness answered yes, should have been sustained, and they weren't. And under the doctrine that we have discussed before of curative admissibility and the open the door issue, and this isn't even open the door, I objected to them. My objections were overruled. The people should be allowed to go into this. The jury should not be left with the impression that there is a factual basis and a good faith basis for counsel's questions when they know that they are contrary to the testing that was performed by the FBI. And if the court would like, we can go and try to find the exact questions, and there were a series of them that were asked by the defense in the record.
Mr. Blazer?
Your Honor, we strenuously object. Mr. Goldberg has just acknowledged that he asked questions that he knew was improper, and every time he does it, he turns to face the jury, and you can tell from the first 3 words of the question that they're improper. He knows they're improper. He's experienced enough to know that, and we object to that. The hypotheticals we asked, he objected to, you sustained, or you overruled the objections. We're allowed to ask the hypotheticals. You've sustained all these questions. He continues to ask them. We would ask that some appropriate sanction be imposed.
Mr. Goldberg, any response? I'm concerned about your admission that you knew that those questions were improper.
Your Honor, wait a minute. I have always tried to be very candid with the court. And in instances such as the staple issue, I told the court exactly what I was thinking. It would be intellectually dishonest for me to say that giving a hypothetical to a witness of facts relating to testing that he doesn't know of would be a proper hypothetical question. But the court also knows that I have disagreed about a lot of the hypothetical questions that have been given by the defense and by both sides. And what I am saying is that the court apparently has a different view than I do as to the propriety of certain hypothetical questions. And I am practicing law in this court under Your Honor's rules. And if the court allowed, and you did allow them to ask what now Mr. Blazier is by implication admitting he knew to be improper, because he asked the same series of questions that I did, with one distinction, and that is that he knew that there was no good faith basis for his questions, and he knew that they were contrary to the testimony that is eventually going to be introduced, then I believe under the rules as Your Honor has set them forth, and Your Honor does have discretion in this, I'm not saying the court is wrong.
Wide discretion.
Wide discretion. If the court has found in a proper exercise of its discretion that they can ask the question, then I can ask the question. That does not mean that I personally as an advocate think that either side should have been allowed to ask. But it means that under the rules that have been imposed here by Your Honor, using the discretion that is inherent with this court, that I believe that that was a proper question with respect to the rulings that have previously been made on that issue.
The problem I have with your hypotheticals, Mr. Goldberg, is that they bring in as hearsay EDTA testing results. That's the problem.
But the way I phrased my question, some of them may have been
About the
phrased.
only EDTA question that appears to be proper in this line of questioning is how much is the standard amount of EDTA in one of these vacutainers, and how much would that add to the blood volume in this case? But apparently nobody wants to ask the only obvious question that this jury is interested in hearing. And I don't know if you're watching the jury at all, but they're rolling their eyes every time we get to the fifth or sixth question that's been re-asked and asked again. And this dueling hypothetical questions is really argument at this point, counsel.
Your Honor, if the court were going to strike...
We're in recess.
Thank you. Dealing with the reporting of inconclusive results and showing that his reporting of the inconclusive results is in fact consistent with the Code of Ethics. So it opens up a whole new area that we haven't gone into. As I understand it, Your Honor, the remaining items here are simply larger versions of what we've already gone over.
All right. Mr. Blazier.
Your Honor, as to A and B, Mr. Goldberg asked on redirect, and I asked the court reporter to provide me with a copy of this. They don't have the full transcript yet, so this is probably not the page number that's going to be on the full transcript. But the question was asked, now, when you were testifying on cross-examination, at one point you said that biological contamination, in other words, contamination of one type of blood with another type of blood, would not change the type of the blood that was contaminated. What did you mean? Answer, well, you're not going to... The type of blood isn't going to change. It will still be what it always was. That's the nature of the genetic markers that we deal with as a rule. So by introducing another one, it will not change it. It may overpower it, or it may degrade it, or something else like that, but it will not change it. These two charts are I want to ask him questions about that answer and to demonstrate that half of the answer is inaccurate, that you can have it overpower it or degrade it like he's testified and have a different type show up. Chart number C.
How do these two charts demonstrate that?
Well, he's already testified about you get one allele from mom, one allele from dad. We talked about it in the context of EAP and DQ alpha as well. Mm-hmm. So you know what the type of the child is by what type of the parent is. And I'm going to ask him some questions about if you mix some blood from person A and person B together, you're going to get a type that's a combination of both of those, which is different from the type of either one of them.
So you're suggesting in these charts that these mixtures are actually mixtures of bodily fluids?
Yes, blood.
All right.
And chart number 3C that's simply the degradation chart with, that's exactly what he testified to, that Saperstein says is there's one other route of degradation that would give you just the higher B band. The red blood cell chart, that's just straight science. I'm sure Mr. Matheson knows that EAP is found in red blood cells that don't have any DNA. Chart number 5.
What's the relevance to this?
Well, because the relevance is you can't, you can do all sorts of other tests other than EAP, and you're never going to be able to rule out that the EAP came from someone who was a B. That other tests won't allow you to do that. You have to, the only way to do that is to retest the EAP. And chart number 5 is simply to show that if you have fingernail scrapings, they are going to contain material, obviously from the person whose fingernails they are, including skin cells. The fingers are made up of cells, the fingernails are made up of cells, and they contain DNA.
So this is the same argument, the EAP is separate from DNA testing?
Yeah, similar, yeah. And then the 2 Code of Ethics provisions I provided yesterday.
All right. All right, the objections will be overruled. All right, I'm sorry.
Can I respond to those?
I heard the arguments.
Okay, what about the issue that the court, the
All right,
other
as
issues?
to the hypothetical questions, you want to direct my attention, Mr. Goldberg, to the location in the transcript?
I'm looking at page 51.
Which volume?
Well, it's yesterday's transcript. I don't have a volume number.
Mrs. Robertson, would you tell Ms. Olson I need the transcript, please?
While you're waiting, it doesn't appear that you want to get to the next 2 witnesses this morning. May I release them? One, 2, anybody?
Yeah, I'd say that's a fair guess.
Thank you.
And Mr. Goldberg, you want to direct my attention to which one we're talking about?
I'm looking at line 21 on page 55,
Page 55?
where does the court want me to read it?
Why don't you
or-
read it to me?
Mr. Blazer, hypothetically, Mr. Matheson, if blood from this case, from an evidence item such as from the back gate, showed the presence of a chemical, EDTA, would you agree that it is consistent with it possibly coming from a reference vial? Then there's an objection. That's an improper hypothetical. It's inconsistent with the known facts. Overruled. Witness, as you stated it, if it was present and if it was able to be identified in it, it is possible that it could have come from some type of reference sample that previously contained EDTA.
So you want to ask the hypothetical, assuming the same facts, except no EDTA is found.
Yes. And then there was actually a second hypothetical, which I also objected to in a similar vein.
And I would object to that hypothetical for lack of foundation. The foundation being that testing can only determine whether something, can only detect something that's there. If they get no results on a test, that doesn't mean it's not there. If he modifies it to that extent, then I have no problem with it.
All right, but what's the good faith basis of your offer, Mr. Goldberg, that there's no EDTA in?
The good faith basis of my offer is that in reading the FBI report, that's what it says. That is what the verbal description of their testing says.
The verbal?
The written description of the testing.
Okay.
I'm sorry, Your Honor.
Okay. I will allow that one hypothetical question as phrased. All right.
Okay, I'll phrase it almost identically to what the defense did, except not, adding
Right.
the words not.
All right.
Your Honor, for the record, I'm prepared to state what my good faith basis for asking that question was. And that is that our experts have looked at the FBI results and have said that it's present.
So I assumed given the nature of our discussions and the other things that have gone on, that you had a good faith basis for asking that.
Yes.
I didn't ask for that.
I'm sorry.
Okay. Thank you for providing that to me, but I didn't need it.
We have a discovery issue that just arose a few seconds ago in the
That
last
appears to be so too,
Yes.
but let's take that up after we finish with the jury this morning.
Thank you. Okay.
All right, sort of piqued my interest as well. All right, Deputy Magnar, let's have the jurors, please. All right, Mr. Matheson, would you resume the witness stand, please? All right, Mr. Goldberg, you may conclude your redirect.
Thank you. Were you trying to run out on us, Mr. Matheson?
No, I was standing right in front of the door.
Mr. Matheson, I just want to ask you, hypothetically, if blood from this case, hypothetically, if blood from this case, from an evidence item, such as from the back gate, showed no presence of a chemical EDTA, would you agree that that is inconsistent with it possibly coming from the reference vial?
Yes, I would.
Thank you very much, Mr. Matheson. Thank you, ladies and gentlemen.
All right, Mr.
No further
Blazier.
questions.
Thank you, Aaron. Mr. Matheson, would you agree that tests that are performed to determine whether something is present or not can only determine that if there's a certain amount of something present? In other words, if there's something less than the sensitivity of the test, you won't detect it, correct?
Vague, improper, hypothetical.
Or will.
Yes, if it's below the detectability limit of that test, you won't see it.
So something, it could be present, but your test won't show it.
If it's below that level, yes.
I'd like to
I'm sorry, Mr. Is it possible for us to document in some way the way that the vial appears now before council? Oh, it's been done. I'm sorry.
Mr. Matheson, you were asked a number of questions about an experiment that you performed last night. Recall that?
Yes.
Now, when you performed that experiment, did you videotape or take any photographs of what you were doing?
No, I did not. I was the only one left in the lab.
Did you invite anybody from the defense to observe?
No, I did not.
And a lot of the numbers that you've used for purposes of your demonstration are numbers based on your guess as to how someone else may have done withdrawals at particular times, correct?
This states the evidence.
Sustain, rephrase the question.
You had no personal knowledge of how a number of the withdrawals that you testified about were actually done, correct?
I had personal knowledge because I was involved in at least two of them. The other ones, no.
Now, when we visited the lab in January, Mr. Taylor did his measurements with a ruler. You recall that?
Yes, I do.
That was after you had done your precise measurement of 2.6 milliliters, wasn't it?
It was after I did my measurement, yes.
Were you asked any questions at all by me or Mr. Goldberg about any measurement that resulted from a photograph with a ruler?
No.
When we were in the lab, were we permitted to open up the blood and take the blood out?
No, you were not.
Now, you testified previously that your records indicate that as of June 20th, according to toxicology, there is 5.5 milliliters in that tube, correct?
That's what was in it on that form, yes.
And that's as of June 20th. At that time, there had only been one withdrawal from that blood vial that we know about, correct? From the records.
That's correct.
And assuming again, hypothetically, that you started with 8, Mr. Yamauchi indicated that approximately 1 milliliter was taken out for typing, correct?
Yes.
Incidentally, you don't need nearly 1 milliliter to do the kind of typing you did, do you?
The kind of typing who did?
Mr. Yamauchi did on the 14th.
Not relevant beyond the scope.
Overruled.
Well, actually, I believe the reference was that he used a milliliter for swatching, not just for his testing.
Okay. Now, for the type of swatching that he did, do you need a milliliter, or do you actually use a lot less,
Calls for speculation.
if you know?
Well, my understanding is you use a milliliter for those Fitzco cards, the ones that we demonstrated before.
Okay. Now, would you agree that under the hypothetical, as of June 20th, there is 1.5 milliliters, Mr. Simpson's blood, that according to your records, and assuming my hypothetical of starting with 8, that are not there at that point?
Argumentative as an
Oh.
answer.
With all the assumptions in place, yes, it would be approximately 1.5.
And as of that date, there's only been one pipetter that went into that tube according to the records, correct?
That's correct.
And did you, in the course of your experiment, did you determine how much you would have lost by putting a pipetter in one time to determine how much of that 1.5 milliliters would have been used up that way?
No, I didn't, just the aggregate of all the ones.
Certainly, it would be an extremely small amount. Would you agree?
It would be small, yes.
Would you also agree that the pipetters that are used, well, let me ask you this. How much do the pipetters that you've demonstrated to us hold?
No foundation.
Overruled.
Which pipetters are we talking about?
Well, do you know what kind of pipetter Mr. Yamauchi used?
For his 1 milliliter?
Yes.
No, I do not.
The $300 pipetter that you showed us this morning has a plastic tip on it, correct?
Yes, it does.
And do you know who manufactures that plastic tip?
No, it's called an art tip, A-R-T, but I don't know, I can't think of the manufacturer right now.
Are you aware that some plastic tips have a coating on it to prevent liquids from adhering to them?
Assumes facts, not in evidence.
Overruled.
I don't know if they're specifically coated with anything, no.
But are you aware that plastic tips that blood or other fluids don't adhere to plastic tips as they might to glass?
Assumes facts, not in evidence.
Overruled. Do you know that?
I'd say it depends on the plastic, depends on the glass.
Now, using the $300 pipetter, how much does that plastic tip hold?
Well, the pipetter that I demonstrated here is a 1,000 microliter or 1 ml capacity. When you draw it up, there's a little space on top of it. So, but you don't want to use, I mean, that's your maximum is 1 milliliter, but it could hold a little more.
And the little plastic one with a bulb built into the top, how much does that hold?
I don't know.
Is there a marking on there to indicate 1 milliliter?
I could take a look at the one we have and see if it says
Okay.
something on it. No, I don't see any markings on it at all.
Now, the glass one that doesn't have the bulb on it, does that have any markings on it?
No.
Would you agree that a trained forensic scientist who intended to draw 1 milliliter out of a blood vial would know the difference between 1 milliliter and 2.5 milliliters?
Calls for speculation.
Overruled.
Yes, I would think so.
Now, you indicated that when you take the tops off of these purple top vials, a lot of times you get blood that comes out of them, correct?
Well, I think I mentioned that there's some adhering to the cap, and when you remove it, some of the times that gets transferred onto chem wipe.
And are you aware of what's known as an aerosol effect?
Goes beyond the scope of the redirect
Overruled.
request.
Yes, I am.
What is that?
Well, it's when you apply some force or something with the liquid, it forces it out in very small droplets.
In almost like a spray, if you had a spray bottle of something?
Yeah, that's an aerosol effect too. You're taking and squirting a spray bottle and then putting it into the air.
And that blood would have DNA in it, correct?
Beyond the scope.
Overruled.
The blood that is aerosolized?
Yes.
Yes.
And you used the term in your redirect testimony, splattering, correct? Do you remember using that term?
Blood spatter, yes.
No, I think it was splattering.
In what context, counsel?
In terms of when you open the tube, having blood come off of the top.
I think he's already described that.
Okay. Now, when we were at the lab in January, Mr. Taylor, myself, and several others, we asked you specific questions about the withdrawals from this reference tube, didn't we?
I believe so, yes.
And you told us that when you did your withdrawal on the 27th, you put what you didn't use back, correct?
Asked and answered.
Overruled. I assume this is foundational for something else.
Yes, I did, but I believe I probably qualified it with, to the best of my knowledge or something like that.
Do you remember doing that? You remember putting any qualifications on it at all?
No, but I normally do if I don't have very specific memory of something.
Was your recollection better in January than it is today as to whether you put the blood back?
Assumes facts, not an evidence, and not a recollection.
Rephrase the question.
You wouldn't have told us that you put it back if that wasn't your recollection, would you?
Assumes facts, not an evidence.
It's argumentative the way it's phrased.
When you talked to us, did you tell us to the best of your knowledge what you had done with the blood that you used?
Asked and answered.
Overruled.
Yes, I did.
Now, do you recall us having a discussion about how much was used in toxicology and where that .70 figure came from?
Are we talking about in court?
No, I'm sorry, in January.
No, I do not.
Now, the microcentrifuge tube, that's the tube that went to toxicology, correct?
I believe it's the one that was prepared by them.
And that holds a maximum of 1.5, correct?
That's correct.
And by your measurements, when it got back and got put back in the envelope, it had .8 left, didn't it?
I believe so, yes.
And that would indicate, would it not, that .7 was no longer there.
That's correct.
You remember a discussion at that same meeting? Incidentally, Mr. Yamauchi was present as well, wasn't he?
He might have been. He was involved in a number of those.
And do you recall a discussion at that time that involved him about how much he actually withdrew on the 27th? I'm sorry, the 25th.
Sustained.
Do you recall during that meeting taking any issue with anything that Mr. Yamauchi said about what he had done?
Still calls for hearsay, not relevant.
Overruled.
Now, what does the term examiner bias mean?
Not relevant.
Overruled.
Well, my understanding of that would be is that examiner being the person that's doing the work, I can have a certain bias or slant or something along that line that exists within them.
Is another way of stating that sometimes an examiner might come to the conclusion that he thinks he's supposed to come to, not necessarily fraudulently but just because you know the result and you tend to see what you think is supposed to be there. You understand what I just said?
Not really, no.
I don't think I did either. Doesn't that mean that your preconceived idea of what the test results should be has been shown by studies to possibly affect the result that you actually see?
Beyond the scope of this witness's expertise.
Sustain the way that's phrased.
Psychological issue.
Tell us what you mean by the term examiner bias.
Well, if a person has a bias, then they have a preconceived notion or leaning towards one particular idea or something.
And one of the techniques, and I think you testified about this in terms of how much information you know versus not having any information, is to read test results in a blind sense where you don't know anything else about the rest of the case, so you don't have any preconceived idea of what the answer is supposed to be. Correct?
That's correct.
Now, you remember the cranberry juice we talked about, Mr. Goldberg asked you about a little while ago?
Yes, I do.
And I represented to you when we did that little experiment that it started with 8 milliliters, correct?
Yes, you did.
Now, when you look at a tube, we measured that in a little graduated container, correct?
Yes,
And you recognize that as the type of container that you use if you want to measure quantities, or one of the types, correct?
it's one of the types available, yes.
And when you pour something in there and you hold it up and you estimate how much is in there, you look at the liquid and you compare it to the markings on the tube, correct?
That's correct.
And when you looked at that, did you take your measurement from, withdraw? When liquid is in a tube like that, a relatively small tube, it tends to bow down in the middle, doesn't it?
Yes, it does.
So if you take a measurement from the bottom of the bow, it's going to be different from the top of the bow, isn't it?
Talking about the meniscus?
Meniscus.
Yes, if you take it from the top, you're supposed to take it from the bottom of the meniscus.
Now, if I indicated to you hypothetically that when I measured the 8, I took it from the top, that would have been an incorrect way to measurement.
No, that's improper.
Sustain.
You'd get a difference if you measured it from the top versus the bottom.
Of the meniscus, yes.
Okay. Now I want to ask you a couple questions about security at the lab. Now the computer printouts that you identified and testified to on redirect only include lists of employees who may have entered those rooms by presenting their ID card, correct?
That's correct.
And anybody who initially enters that unit that may have somebody else with them when they go in, that second person's not going to show up on any record anywhere, correct?
That's correct.
In fact, the times that we've been out there where you've shown us that room, our names don't appear on any computer printout as a result of going into that room, correct?
Right, because you're not issued a card.
And that particular, and for instance, on the morning of June 14th, if Detective Lang was in that room, he doesn't show up on any printout either, does he?
Overruled.
No, his name wouldn't show up. He doesn't have a security card for our facility.
Incidentally, the detectives that you work with in robbery homicide, for instance, they know where the evidence processing room is, don't they?
I don't think all of them would. Ones that have been in our facility would.
And when you dry the blood swatches, they're always dried in that cabinet up on the wall, aren't they?
That's our designated drying spot, yes.
And the records that you testified to only show when a door is opened, correct?
Actually, it only shows when somebody displays their card, it reads the card, then it unlocks it.
Now, is there any record in the computer when somebody who is inside the room goes out?
No, there's not.
So those records, there's no way you can tell from those records how long people who went in at a particular time stayed there.
This has been asked and answered.
Overruled.
That's correct.
Now, the garage door that we've been referring to, the roll-up door, does that require any kind of card entry from the outside?
Seems to be open from the outside.
Overruled.
That door does not require a card to open it up, no.
So if that door were open, there would be no record, no computer record of who might have gone in that door or who might have gone out of it.
Well, to open that door, we'd have a record of who was in the evidence processing room, because that's where you open it from. Once it was open, no, that we would not have a record of
Well,
that.
I'm sorry, were you done?
Yes,
Let's assume that you have Mr. Fung come into the evidence processing room with somebody with him. Now, that entry would show up, and it would show up as Mr. Fung, correct?
that's correct.
And then the door is open, and Mr. Fung leaves, but the second person stays. There'd be no record that the second person was in there alone, would there?
Overruled.
That's correct.
Now, the documents that you testified to are only authorized entries into that room, correct?
Yes,
If somebody was able to get into that room who was unauthorized without triggering the computer system, there'd be no record of that, correct?
not on that printout, no.
Now, you also indicated on redirect that you asked some questions about evidence possibly being moved from a crime scene. You recall that? In terms of whether there's full documentation by taking pictures?
Oh, as to whether or not it had been moved from its original location prior to collection?
Correct.
Yes, I do.
And you recall stating that as long as you had a picture of it before it was moved and a picture of it after, then that would be sufficient documentation for you.
Sustained.
Well, do you recall making a statement about the fact that if you had a picture of it in its original position and a picture of it later when it may have been moved, that, in your view, was sufficient documentation of that item?
It's sufficient documentation of the fact that it had moved, yes.
Tells you nothing about what was done with it between the first picture and the second picture, does it?
That's correct.
Tells nothing about whether someone picked it up, took it someplace, held it, and then put it back, does it?
Sustained.
Now, you were asked some questions on redirect about the blanket. And you recall testifying that you wouldn't have collected that, one of the reasons being that it appeared to have just the victim's blood on it. Remember saying that?
Sustained.
Do you recall,
It's incomplete.
do you recall the reasons why? Tell us the reasons that you told us yesterday as to why you wouldn't have collected that blanket.
Overruled.
Well, I believe I said I probably wouldn't. You know, it depends. There is some variation in how we work when we're out in the field. And I think the reasons that come to mind is that it is an item that was brought into the scene after the fact. It was not present when the crime occurred. And that, you know, if you're visually looking at it and it is very heavily blood-stained, known to have been placed over the victim, their assumption is the majority of the blood on there is going to be from the victim, and it does not have a lot of evidentiary value associated with it.
Now, let's assume hypothetically that there were drops of blood on the victim's shoulder area from some source other than the victim, and a blanket was put over top of that. Could that blood have transferred to the blanket?
It's a hypothetical question. Overruled.
If that blood is damp, yes, it could transfer to the blanket.
So under that hypothetical, that blanket, if that indeed happened, could have contained the blood of someone other than the victim.
Given the hypothetical, yes.
Now, you were asked some questions on redirect about getting to the crime scene before the coroner. You recall those?
I believe there was some, yes, about when the coroner should be called and the body's removed.
Now, you also were asked some questions about whether it's preferable to process a crime scene during daylight hours or during nighttime hours, correct?
Yes.
Do you have any information indicating that the reason the detectives did not call CID or SID for 7 hours had anything to do with processing the crime scene in daylight hours versus nighttime hours?
Argumentative.
False or speculation.
Now, I think you indicated that at some point detectives may decide to process a crime scene themselves,
Yes, that does occur.
including making swatches.
Yes.
Overruled.
including logging evidence.
Yes,
Do you have any information indicating that the detectives that were at the Bundy scene between approximately 12 and when SID arrived later that morning processed any evidence that they recorded?
Overruled. The jurors know what time, the time sequence. Any evidence of that, to your knowledge?
not that I can recall at this moment.
All right.
Now, you were also asked on redirect examination if you had seen any evidence or indication of evidence being tampered in this case. You remember being asked that?
Yes,
Now, would you agree that by your testimony, you don't know how many swatches were collected, so you cannot tell us if the number of swatches that are in the evidence now is the same number as the number of swatches collected originally?
Asked and answered, argumentative, beyond the scope.
Overruled.
that's correct.
Now, you learned at some point that Andrea Mazzola's initials were not on many of the bindles that relate to the blood drops that were collected.
Calls for hearsay, vague as too many, beyond the scope.
Overruled.
You became aware of that, did you not?
I believe so, yes.
In fact, you became aware that her initials didn't appear on any of the bindles, correct?
This states the testimony.
Overruled. Were you aware of that?
That they didn't appear on any of them?
Yes.
Not as I'm remembering right now.
And would you agree that, well, you were also aware of Andrea Mazzola's testimony at the so-called split hearing in August, I believe?
Not relevant.
Sustained.
You indicated you were asked some questions about contamination and an article by Bruce Bedoli of the FBI. You recall those questions?
Yes, I do.
And do you recall making a statement yesterday in redirect to the effect that contamination becomes a problem if it's occurring and you don't know it's happening?
This states the testimony.
Overruled.
Yeah, in use of the word problem, because
Yes.
contamination does occur, if it's going on, you don't know about it, that is a problem.
And if it's going on and you don't know about it, you have no way of knowing how it might affect test results, do you?
If I don't know about it, that's correct.
So if there was evidence in your laboratory of persistent contamination that you were unaware of, would you agree that'd be a serious problem?
Proper hypothetical, argumentative, sociologically impossible.
Overruled.
Would you agree that would be a serious problem?
If there was something going on that we had no idea that it was going on,
Contamination.
given that assumption that something like that could happen, that would be a problem.
Now, you were asked some questions about the computer system and the fact that it's password protected. You remember that?
Yes, I do.
And a password is a secret word that you're given if you're allowed to have access to a computer so that you can actually get it to work for you, correct?
That's correct.
And what that means is if you don't have that word, you can sit there and punch buttons all day and you're not going to be able to get into the computer, correct?
That's correct.
Now, that particular protection that you described wasn't in effect for any of the evidence in this case until the 16th of June, correct?
Vague, overbroad.
Overruled. I think we've already established the date that these things were entered into the computer, correct?
Correct.
All right.
Could we take down that exhibit and yesterday, you were asked about biological contamination in the context of whether having one sample contaminated with biological fluid from another sample could cause the first sample to change type. Remember that?
Yes, I think we've talked about it a couple times.
And you said that that can't happen.
And actually changing the type,
Yes.
that's my understanding, yes.
Now, when you're talking about actually changing the type, let me shift that just a little bit and ask you the same question about being able to detect. Well, let me rephrase that. The only way we have of knowing of what a type is by the test, correct?
That's correct.
Now, is it your testimony that if you have a biological sample from one person and another biological sample is added to that from a second person, that the results of the test would never change?
No, I did not say that.
Now, can we have slide, I need a number for the slide presentation.
Defense next in order,
1143.
1143A.
Now, Mr. Batson, you remember yesterday we were talking about that you get genetic markers come from our parents, don't they?
Yes,
And we talked in the context of the EAP system of there being A's, B's, and C's, and you get one of those from each parent, correct?
that's correct.
Same thing is true with other genetic markers that are looked at in DNA testing and other conventional serology testing, correct?
Yes, the concept's the same.
Each marker system has its own universe, if you will, of possible alleles, they're called, within that marker, correct?
Beyond the scope, Your Honor.
Oral.
Correct.
That's correct.
And one of the marker systems that you, in fact, you look at in your lab is called the DQ alpha marker, which is, that just identifies a particular part of the DNA that's looked at, correct?
Yes, that's true.
And that's the primary test that your lab performs, isn't it?
That's one of a couple tests, yes.
And two of the alleles that happen to be in that system are called 1.1 and 1.2, aren't they?
Yes,
It's kind of the equivalent of the A's and B's and C's, correct?
This is beyond the scope, Your Honor.
Oral. But move it along, Mr. Blazier. This is just to make a point.
Yes,
All right.
correct.
Let's get there.
that's a designation, yes.
Now, if you inherit that 1.1 from your mother and 1.1 from your father, then you're going to be a 1.1, correct?
Beyond the scope.
Oral.
Yes,
And correspondingly, if person B up there inherits a 1.2 from mom, a 1.2 from dad, that person's going to be a 1.2, correct?
yes,
Now, if you take a little bit of blood from A and a little bit of blood from B and mix it together and run a test on it, you're going to get a type 1.1, 1.2, correct?
Vagus a little bit.
Oral.
depending on the concentrations of each, yes, you're going to see those too.
Let's assume they're approximately the same.
That's what the test would read then, yes.
And the 1.1, 1.2 type is different from either of the two types that went into it, correct?
When taken together, that's correct.
Now, would you agree that that is an example of where you could have a mixture of blood from two people that would type differently from either one that's in it?
It would change the result you see, yes, not the type of either one of them.
Okay, but all we have is the result, correct?
That's correct.
Now, you also indicated yesterday that the nature of the genetic markers that you deal with, one marker might, I think the term you used was overpower, or one might degrade, correct?
Beyond the scope, that wasn't on redirect.
Yes, it was.
Oral.
I'm sorry, could you repeat that?
Yeah, let me read you a question and answer from yesterday to see if this refreshes your memory. Or let me show it to you. Okay.
It's irrelevant whether you remember his testimony from yesterday.
Oral.
Yes,
Saw that yesterday.
yes,
And the concept you were talking about there was if you have this mixture that we've been talking about, if you've got part of the mixture is either degraded or you've only got a little bit, it may be overpowered by the other component, correct?
Asked and answered beyond the scope of the rule.
Yes.
Now, in my example, my hypothetical up there, would you agree that if person number A had been, that sample had been degraded or was only a small sample, and person number B had a lot there, and you mixed them together and did a test, person number B might overwhelm person number A, correct?
Asked and answered.
Yes, that's possible.
And, next slide please, slide B. Do you agree that in my hypothetical, that would result in your final test of this mixture showing person B, but not person A?
Assuming that the quantity of B was sufficiently high, yes, that could occur.
Now let's assume hypothetically that the blood from person A is put on a swatch, and the degradation simply means the little pieces of DNA are kind of breaking up and you lose the ability to detect them, correct?
Beyond the scope, Your Honor.
Sustain.
And if hypothetically blood from person B gets put on that swatch later on after A has started to break down, then you might get the hypothetical that's up on the projector.
Beyond the scope.
It's an improper hypothetical. Sustain.
Now, Mr. Matheson, I want to ask you a couple of questions about the EAP testimony that you gave on redirect. You recall Mr. Goldberg asked you specific questions about the articles that I had referred you to. You remember that?
Yes, I do.
Now, let me ask you first of all, the only article that you referred to on direct was the Zajac, Grunbaum, and Krim article, correct?
That was
Relevant, Your Honor.
That's right.
that was the only one presented to me, yes.
Now, let me show you that article. Have you read that recently?
I've read this, and yes, it's been within the last several days.
And you've given testimony on redirect about the manner of degradation of an EAP, have you not?
Yes, I have.
I'm sorry, of a BA.
That's correct.
Would you agree that that particular article that you referred to, nowhere in it talks about how a BA degrades in terms of what happens to the bands, does it?
Did you ask whether or not that makes any reference to any form of specific type of degradation?
No, my question is, it doesn't tell you which bands you lose in what order when you degrade a BA, does it?
No, it does not.
We have slide C.
C.
Now, you recall yesterday we had a slide similar to this to illustrate the path of degradation of a BA down to a B, correct?
It had similarities to this, yes.
Now, one article that you were shown by, or asked about by Mr. Goldberg on redirect was the Yeshian article. Remember that?
Yes.
And you testified that article said nothing about the manner in which a BA degrades in terms of which bands disappear first. Do you remember that?
misstates the testimony.
Rephrase the question.
You recall testifying that that article did not ask you to read first paragraph under discussion.
Yes, I have.
I'm sorry, of a BA.
That's correct.
Would you agree that that particular article that you referred to, nowhere in it talks about how a BA degrades in terms of what happens to the bands, does it?
Did you ask whether or not that makes any reference to any form of specific type of degradation?
No, my question is, it doesn't tell you which bands you lose in what order when you degrade a BA, does it?
No, it does not.
We have slide C.
C.
Now, you recall yesterday we had a slide similar to this to illustrate the path of degradation of a BA down to a B, correct?
It had similarities to this, yes.
Now, one article that you were shown by, or asked about by Mr. Goldberg on Redirect was the Yeshian article. Remember that?
Yes.
And you testified that article said nothing about the manner in which a BA degrades in terms of which bands disappear first. Do you remember that?
States the testimony.
Rephrase the question.
You recall testifying that that article did not describe the path of degradation of a BA.
No, it states the testimony.
Well,
From my understanding of the articles, I believe it describes a different, the focus of the article is a different degradation, the B to a CB or something like that.
Okay, let me show you that article. I ask you to read the first paragraph under discussion.
Okay, under discussion, it says several studies on,
just read it to yourself.
oh, I'm sorry. Okay.
Now, that article does describe the path of degradation in terms of which bands disappear first, doesn't it?
It does have a two-line reference to it, yes.
And it refers to that as being an analysis of other literature on the topic, correct?
It references several studies, yes.
And it says that all of those studies describe the path of degradation the way I did on my cross-examination with you, correct?
Yes, it does.
Not the way you described it, correct?
Well, Mr. Matheson did describe it in one way.
Sustained.
Not the way you described it as leading to 2B bands, correct?
That's correct.
Now, you were asked a question about the book that you had referred to, the Saperstein's book. You recall that?
Yes, I do.
And the chapter of that book that you were referring to is actually written by Dr. Sensabaugh, correct?
Yes, I believe we
And
mentioned that.
I'm sorry. And he's the same author that of the article that I provided to you during cross-examination, correct?
That's correct.
And that article, the portion that you read from that article, describes one other possible path of degradation for a BA, correct?
I think it gave indication of that, yes.
And could you read again starting at the thus, which you read yesterday, and read down to where it says 2.
Where it says what?
The next sentence where it starts with 2.
Oh, okay. Am I reading this one out loud?
Sure.
Thus, one might expect the A bands in BA and CA types to be lost before the B or C bands are lost, and this, in fact, has been observed. That's the end of the sentence.
I read the next sentence.
Okay. In typing aged type BA bloodstains, for example, only the major B band, and then in parentheses, the anodal B band, may be apparent, and the temptation would be to type the sample as a B type.
And would you agree that what that says is that you might also get a path of degradation that leads you to just seeing the B2 band and nothing else?
Yes.
And then the next part of that says what?
Since it has been observed that in aged BA bloodstains, the slow B band is generally lost before the fast A band, The controlling rule is to withhold judgment on a putative B type until both B bands are apparent. If the sample is in fact a BA type, the major A band should be apparent by that time.
Would you agree that what that says is that if you have both B bands, B1 and B2, that cannot be a degraded BA?
No, I believe it says things like generally and should. It's not an absolute.
Can you cite me to a single scientific reference that says that a BA can degrade to the point where you have two B bands and nothing else?
No, I cannot.
We go to slide D, please. Now, the EAP test measures an enzyme in the blood, correct?
Yes, it does.
And it's an enzyme that's found in red blood cells, correct?
That's correct.
And our blood is made up of red blood cells and other types of cells, correct?
Beyond the scope.
Yes,
And there's no DNA in a red blood cell, correct?
that's correct.
The DNA, our DNA is found in cells other than red blood cells, correct?
Yes,
So if you're doing a DNA test on a biological fluid that contains a lot of cells, you're only looking at what's in cells other than red blood cells, correct?
for the DNA, yes.
Now, can we go to slide E? Now, Mr. Matheson, would you agree that our hands and fingernails are made up of cells?
Yes, they are.
And would you agree that if you took scrapings from under a person's fingernails, you would expect their DNA to be in it, wouldn't you?
Their own DNA?
Yes.
If you scraped and picked up some of their skin or blood or whatever happened to be under there.
And if you did that kind of a scraping where you got cellular material from under the fingernails, if you didn't find the person's DNA, that would be unusual, wouldn't it?
Beyond the scope.
Well, I haven't done DNA typing under fingernails, so I don't know if it'd be unusual or not.
Now, you could also, could you not, let's assume hypothetically that you have a person with fingernails that scratches somebody else who has an EAP type B. Have that hypothetical in mind?
Yes,
And a small amount of that, a person B who has an EAP type B gets under the fingernails of person A. You with me so far?
think so.
And you took scrapings from under the fingernails and did a series of tests on them. Would you agree that when you do the EAP test, you're going to detect the EAP type B from the person who was scratched, correct?
If there's sufficient blood present, the detectability limit of the test.
Now, would you also agree that if you had a greater amount of material, cellular material from person A, and you did a DNA test, that you would detect the DNA of person A in that mixture, wouldn't you?
If there's sufficient amount, yes.
And if the amount of DNA from person A overwhelmed the amount of DNA that might have come from the small amount of blood from person B, you'd never see person B, would you?
It's beyond the scope. It's getting into DNA.
Do you understand the question?
Yes. If the quantity of DNA provided by the tissue that was scraped was significantly higher than or sufficiently higher than the blood providing the AP, then yes.
And would you agree that you can do as many DNA tests as you want on that mixture, and you're never going to be able to prove that person B
Sustained.
isn't there?
Sustained.
I'd ask the jury be admonished to disregard the import of that question.
They know that when I sustain
Type item number 42, yes.
And I think you indicated that according to the article by Dr. Bedoli, that for that kind of control study to have any value at all, the sample that you're comparing it to has to have been subjected to the same myriad of environmental insults, I think is the way you described it, correct?
This is testimony.
Remember?
I believe on reading that, it made reference to the fact that a blood sample collected from an area where the victim is, that's known to be the victim's blood, would tend to be involved in the same environmental conditions.
But if your control sample, in this case 42 that you testified to about, was subjected to different environmental conditions than the fingernail samples, your control makes no sense. It doesn't work that way, does it?
It's argumentative. It states
Same.
facts, not argumentative.
Rephrase the question.
In my example, the control is not a proper control, is it? If it's not, if that sample is subjected to different conditions than the one you're comparing it to.
Overruled.
Well, it still is going to provide information. It is blood that you know to come from a particular person. If the environmental conditions are not exactly the same, then that is something that might be considered.
Now, you were asked some questions on redirect about wet stains versus dry stains. You remember that?
I think there was some mention of it regarding the studies, yes.
Incidentally, is there a single reference in the literature or a single study that you can point to that says that the degradation pattern of a wet stain is going to be different than a dry stain?
Not that I can recall at the moment.
Now, would you also agree that 84, the fingernails in this case, there were two samples, one from one hand, one from the other, correct?
That's correct.
And one of those samples appeared to be damp because you could see the transfer of material onto the container was put in, correct?
Yes.
The other one was dry, wasn't it?
Well, the other one appeared to be drier. It had chunks of blood down the bottom, but the tip of the stick was a little damp, or a little red, which may indicate that it had a little bit of dampness in it, but there was a difference.
There was a difference in the conditions of those two samples, wasn't there?
Well, vague and overbroad as to conditions calls for
Sustained.
speculation.
Sustained.
Would you agree that if your theory, if your testimony about a control study is accurate, it would only apply to samples that had the same conditions, similar conditions?
Vague is dissimilar.
Overruled.
I think that has to be taken into consideration, but there is still information that can be obtained.
Now, I would like to show on the Elmo I'm not sure what exhibit this is. This is the one that the prosecution did where they printed out with the arrows on it. You remember yesterday you were asked to identify I think you described them as band-like appearances
Yes.
from 42. Show you this just refresh your memory.
Well, let's find out what exhibit it is first.
That may be 224C.
Right.
Let me show you 224C on the Elmo.
Why don't we give Mr. Matheson the other copy of that?
Sure.
And keeping in mind the time limitations.
Yes, we're almost done.
Mr. Blazier.
Now, Mr. Matheson, you recall that you had two arrows put where you saw what you described as something kind of like a band. Remember that?
Yes.
Now, you also testified during cross that there is something kind of like a band or something that you can see between those two arrows, correct?
That misstates the testimony, it's also in the conjunctive.
Overruled.
There is kind of a haze in that area. It's brighter than the background, yes.
And could you direct get an arrow put on that where you see that?
you go to the left, left.
Can we have the arrow on the same side, please?
How about if we have it on opposite sides of the same lane so that we can determine who put what where?
Okay.
Okay, so you need to go down a little bit, down, right kind of in that area off to the left there. There's kind of a hazy cloud of something.
Okay, why don't you click that. Now, that is in an area that would correspond to an A band, correct?
General area, yes.
Now, I want to cover up everything except that lane. Can we print this out first? Matt's not going to cover up everything except that lane. See that?
Yes, I do.
And the technique I'm using is what you described earlier as reading it blind, correct?
No, actually, reading blind that I mentioned before is not having any information about the case. It's very difficult and really fairly inappropriate to read a plate without the controls and things present.
There's nothing on there that you, as a forensic scientist, will call a band, is there?
This is improper, Your Honor. This is not a scientifically correct way of doing it, and also the resolution's not doing that.
Sustain. Foundation.
Is there anything in that lane that appears you would call, as a forensic scientist under your training, that you would call a band?
Same foundational problems,
Oral.
and the resolution's not good enough.
Oral.
I don't believe I've ever testified that I identified bands in that lane, but that there were things or band-like visible areas that were showing up.
Including in the area of an A band, correct?
In addition to other areas of that lane, yes.
And would you agree that your band-like appearances are three areas of some sort of a cloudy thing that you've described, correct?
There's no foundation for this, Your Honor. It's also vague. It's a cloudy thing. It's been asked and answered.
Overruled.
I'm sorry, could you repeat the question?
Yes. You testified now that you see three band-like things,
That
Sustain-
misstates the
that mis-
evidence.
That does.
that you see three areas on there that have a cloudy-like substance, correct?
That misstates the evidence.
What do you see,
Sustain.
Mr. Matheson?
I see areas on there of different intensities of a cloud-like type of appearance.
And that doesn't look anything at all like what you found on the fingernails, does it?
Well, that's an improper hypothetical.
No, it's argumentative the way it's phrased.
It's also a picture of picture.
Sustain.
That doesn't look like what you found on the fingernails, does it?
Argumentative, Your Honor.
Sustain.
Does that look like the bands, does that have the similar appearance to the bands that you found under the fingernails?
Argumentative, Your Honor. Improper hypothetical.
Overruled.
No, it doesn't. If it looked the same, I would have called this with the same result, and I didn't.
All right, let's move on.
Could we have slide, Mr. Matheson, California Association of Criminalists has a code of ethics, do they not?
Yes, we do.
Ask you to look at that and read the highlighted paragraph to yourself.
Your Honor, this isn't relevant. Calls for hearsay.
Overruled.
Okay.
And you agree that those highlighted paragraphs are two paragraphs from the Code of Ethics from the California Association of Criminalists?
Yes, I do.
And you are a member of that organization?
Yes, I am.
And you consider yourself to be bound by those ethics?
Yes.
And I'm wondering if we should print out a copy of that last demo I did.
Your Honor, I object to that because there was no foundation for a scientist looking at something that's covered up like that.
Can we have slide F, please?
Let's proceed with a little alacrity.
Mr. Matheson, would you agree that the code of ethics of your organization that you are a member of provide that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case? In this, I'm sorry, I got it backwards. Let me read the other one. Would you agree that one of those provisions provides that where test results are capable of being interpreted to the advantage of either side of a case, the criminalist will not choose that interpretation favoring the side which he is employed merely as a means of justifying his employment? Do you agree that that's one of the provisions of your code of ethics?
Yes, I do.
Could we see the next slide, please? You also agree that one of the provisions of your code of ethics is that the criminalist will be alert to recognize the significance of a test result as it may relate to the investigative aspects of a case. In this respect, he will, however, scrupulously avoid confusing scientific fact with investigative theory in his interpretations. You agree that that's one of the provisions of your code of ethics?
Yes, I do.
And you agree that there is no scientific support for your testimony that a BA can degrade to the point where you have 2 B bands remaining?
No, I do not.
Isn't that what you're doing in this case, Mr. Matheson, is violating this code of ethics?
Your Honor, this is totally
Sustained.
argumentative.
Sustained.
I have no further questions.
Mr. Goldberg?
Thank you. Mr. Matheson, you are, as a criminalist, bound by a code of ethics. Is that correct?
I am bound of one of the organization that I belong to, and personally, yes.
And does that code of ethics also have a provision dealing with presenting inconclusive results in court?
As far as they would not be,
No, the circumstances under which you are allowed to present those results. Thought we looked at that yesterday, didn't we?
I'd have to review and find out what the
Can you
provision
take-
is.
Can you take a look and see if, may I approach?
Please. See if we can speed this up just a little.
In terms of the EAP issue, did you explain at exhaustive length how you were
Because they are inconclusive. A conclusive result is a final statement. In conclusion requires that some sort of explanation be made.
And at all times throughout your involvement in this case, have you scrupulously followed the ethical standards and guidelines that you are bound to follow as a criminalist?
I always follow them to the best of my ability.
Sir, do you consider your participation in the California Association of Criminalists to be important?
Yes, I do.
And do you consider your job as a criminalist to be simply a 9-to-5 type job, so to speak, or does it mean more than that to you? In terms of the EAP issue, did you explain at exhaustive length how you were considering and why you were considering and presenting maybe marginally relevant explanations at the length to which you went to explain them?
Well, they needed greater explanation than the conclusive results because they are inconclusive. A conclusive result is a final statement. In conclusion requires that some sort of explanation be made.
And at all times throughout your involvement in this case, have you scrupulously followed the ethical standards and guidelines that you are bound to follow as a criminalist?
I always follow them to the best of my ability.
Sir, do you consider your participation in the California Association of Criminalists to be important?
Yes, I do.
And do you consider your job as a criminalist to be simply a 9-to-5 type job, so to speak, or does it mean more than that to you?
No, it means a lot more. It's a profession. That's why I'm involved in the associations and the profession as a whole. Yes, it does.
And you are one of the former past.
That's correct.
And sir, can you tell us what the little lapel pin on your lapel represents?
It's a pin of the California Association of Criminalists.
And have you at any time ever tried to interpret or misinterpret a result in this case, or any of your testimony in this case, to favor the defense?
Sustained. Rephrase the question.
Have you ever tried to present any testimony in this case in such a way as to favor one side or the other?
No, I have not.
And criticized anything that you've said?
It's irrelevant.
Now, Mr. Matheson, I'd like to ask you a few other questions quickly about the EAP issue. I know we've gone into it at exhaustive length, but we'll make it very rapid. As to the Yashan article that you were asked about, was that an article that studied in the sense of doing experiments on the issue of EAP degradation from BA to B?
No, it is not.
Okay. What type of EAP degradation issue was Yashan dealing with?
It was a technical note about a B to a CB.
Okay, so there's some other degradation problems that deal with EAP that we haven't really discussed at length in this case. Is that correct?
That's correct.
Oh, well, we've covered this once already.
And Mr. Matheson, scientifically speaking, does this article, the Yashan article, provide any new scientific information in terms of a study on the BA to B phenomena?
No, it does not.
Now, with respect to the Grunbaum study that we talked about, was there a sample in that study that was in fact mistyped as a B question mark that was a BA?
Yes, there was.
And did Mr. Grunbaum state that in those cases distinct band patterns were present in the cases of the mistypes that occurred in his study?
I believe so, yes.
And what does that mean?
Well, I think the use of the term patterns rather than pattern indicates more than one band.
And you have stated that in your professional career, the BA to B phenomena is something that you have personally seen where there are both B bands present.
Yes.
And that includes a number of instances in this case, is that correct?
Related to this case or other cases?
Well, there are a couple instances in this case, more than one, where you believe it happened here.
Yes.
Now, you were asked about preconceived notions and the effect that that has on a scientist's judgment. When you were typing 42, the pool of blood of Nicole Simpson, had you previously been informed prior to when you did your work by Mr. Fung that that was collected as a sample of Nicole Brown's blood?
Objection calls for hearsay.
Coming in for the state of mind on preconceptions.
It was my understanding that that's what that sample was.
And that's what you believed when you were actually doing the testing?
Yes.
So when you were actually doing the testing, did you believe that the result should be a BA?
Objection. Argumentative. Asked and answered.
It's leading.
What did you believe the result should be prior to doing your test?